will be meaningless. I welcome the court's questions.
Do you think that rights creating language under the enumerated powers is different from the language required under the spending clause?
Well, so the court has said in spending clause cases that the Congress has to speak unambiguously, but at the same time, there's many cases in which the court has required clear statements from Congress, and it has said we don't require magic words from that. Our job is to figure out what did Congress intend. So we look at the words and that Congress enacted and figure out what Congress intended. And I think the way that you can tell that the word right is just a magic words test here, I think from my friends on the other side, and why you don't need it, is because the statute here would do the exact same thing if it said the word right as opposed to what it says now.
So how would this, if it's more demanding under the spending clause, how would the statute differ under the commerce clause? What language would you use if it were if this right were created under the commerce clause?
Well, I think it creates a right either way. I think Congress can write statutes.
I'm talking about the language. If it's more demanding and it's atypical, what language that we have here, you would not need in the commerce clause.
Well, first it's talking about a state obligation, and it's something the state must do to participate. So it starts by saying that it's a mandatory obligation. Second, it says that there's any individual may obtain care from any qualified and willing provider. So it's the combination of any individual may obtain care from any qualified and willing provider. It disables the state from doing something the state might otherwise want to do, like we want to take this provider out of Medicaid for a reason that's unrelated to medical qualifications, which is what the state is doing here. And so it's just the combination of this language makes clear what this provision is doing. I don't think anyone disagrees what this provision is about. Maybe
but do you think that language is more exacting than would be required under the commerce clause?
I'm not certain. I think the court has said that in the spending clause context that Congress needs to speak clearly. My point is just that Congress has spoken clearly here because it has used what this court requires. The court says we want to look to see if there's individual-centric rights-creating language that imposes a mandatory obligation. The court has never said it has to say the word right or it has to be magic words or anything like that. And just to pick up on this idea that we heard maybe for the first time today that there are only certain magic words that count. There's some real problems with that from a separation of powers perspective. Congress writes statutes. It's this court's job to interpret them and figure out what Congress intended. And here it's not like Congress just wrote this statute 50 years ago and nothing has happened. Congress has come back when this court has interpreted the statute in a way that that Congress thought was inappropriate with the Souter fix. And that's a case where, as one of the factors that was considered for whether language created an individual right, not the sole factor, but as one of the factors, this court said in the Souter decision, we see that it's part of the state plan requirements. And Congress came back with language that I think was quoted by one of the justices that said, no, that can't be a reason why, because...
I'm sorry, finish your sentence, please.
It just can't be a reason why.